thank you so much to everybody for being here for National Constitution Day on September 17th. And we are going to start our program titled Insights from Top Constitutional Professors. In line with that, we have assembled top constitutional professors. You guys are elevated. It's just like that. And we're so thankful and pleased that Presiding Judge Hallahan opened up her courtroom for us to use. And I believe Judge Hallahan is close by. She's coming. It's going to be great. And we're going to say a few words about that. The genesis for this is, we need to celebrate this document, and we need to, as things evolve, we need to evolve the document itself. The Constitution needs to evolve as well. And we are pleased to, well, okay, we're ready. Please give it up for Presiding Judge Maureen Hallahan. And as a thank you, excuse me, we'd love to present you with these flowers, including a vase. They're pre-vased. I think that's a term, but thank you so much. Please welcome Presiding Judge Hallahan.
I'm not sure I actually deserve those flowers because my role today is so minimal compared to what you are going to hear from these wonderful speakers and our moderator. And let me just get my stuff settled up here. Good afternoon, and thanks to all of you who are here today. This is a really important day. I don't ever remember celebrating Constitution Day before, but I think in our time and now, it's a really important thing that we do, that we think about, that we remember, and that we analyze. Those are the principles. They're the foundation of our democracy. And the principles that guide our work as lawyers and judges. That is the United States Constitution. I'm grateful for all of you for being here today. It's wonderful to see all of you. It's wonderful to see some of the judges on our court and members of the bar. Thank you again for being interested and for coming. The Constitution is not just an historic document. It is a living promise that protects rights, ensures fairness, and provides the framework for justice. It continues to shape our democracy today. For judges and lawyers, this work is not abstract. Every day, we see the Constitution in action, in the rights we protect, in the fairness we safeguard, and the trust we strive to uphold each and every day in our courts and in our cases for the people of the County of San Diego. Our profession reminds us that the rule of law is not just about rules, but it's about people and about ensuring every person has the opportunity to be treated with dignity and respect, regardless of race, religion, national origin, or sexual orientation. I want to thank Michelle Gastiel, the president of the San Diego County Bar Association, Scott Carr, the executive director of the Bar Association, Jerrilyn Malana, our moderator, former president of the San Diego County Bar Association, and current president of the California Lawyer Foundation. Congratulations to you, and thanks to all of you for putting together this program. I know it was not an easy feat, and I know it was a lot of work. Speaking of a lot of work, I know these professors will be introduced to you later, but they put in a lot of time each and every day teaching the next generation of lawyers. It is so important that we have professors like this who are willing to devote their time, their energy, their livelihood to teaching the Constitution. It's something that we can never forget. I know they'll be introduced more in full later, but I did want to just acknowledge them, Professor William Aceves from California Western School of Law, and Professor Steve Semararo from, did I say that right?
It's okay.
Sorry. Semararo. Okay, thank you. From the Thomas Jefferson School of Law. Again, thank you both for taking the time to be here today. It is critically important, and we appreciate it. Now, I don't expect any uproars today, but the framers of our Constitution and the Constitution itself anticipated and expected a dialogue about the Constitution and several discussions to discuss its meaning and implementation. I would ask that each of you do the same when asking questions or commenting about the program in terms of being respectful to our presenters and respectful to the Constitution. I now will turn it over to Michelle Gastile, who will introduce our moderator, Jerrilyn Malana. But in closing, I want to note that today's program is a chance to reflect on our calling and be reminded that together, through our service, we keep the promise of the Constitution alive. It's as important today as it has ever been. Thank you.
Thank you again, Judge Hallahan. And thank you so much, everyone, for being here. Again, happy Constitution Day. We have some remote law students joining us remotely, and we have so many of you joining us here today in the courtroom. So thank you so much for coming. And thank you so much to our local law schools for partnering with us in putting on this program. We really appreciate it. It brings some expertise to this subject matter, and we really appreciate you being here and working with us. Today is a Constitution Day all over the nation. There are national events happening all over the country. And the values of this national effort there are three. And one is that the Constitution is for everyone. Second, upholding the rule of law. And third, promoting nonpartisan and nonviolent public action. So we really appreciate you sharing those values with us here today. And again, thank you for coming. Now, in terms of questions, outside of the table, there were question sheets that you could write down questions on. If you don't have one, feel free to get my attention once I'm back there with you, and I can hand you a question sheet and a pen if you need one. And once you have your question ready, just wave it around and I'll collect it so that our panelists can review the questions. And just so that everyone knows, you can take pictures and video this program if you would like, so feel free. Well, we're also recording the program, so we're hoping to be able to share it later to even more folks. So without further ado, it's my pleasure and honor to introduce our moderator. She is past president of the San Diego County Bar Association, a member of the Judicial Fairness Coalition, and currently president of the California Lawyers Foundation, as mentioned. So thank you so much. Please welcome Jerry Malana.
Thank you so much, Michelle. It's so great to be here on Constitution Day. You know, it's a day that I think we don't always take a moment to reflect on how important our Constitution is to our community. And as far as the legal profession, of course, as lawyers and as judges. So I'm delighted that under Michelle's leadership that the San Diego County Bar Association has established Constitution Day, and we discussed that this will be a continuing program each year. So I look forward to our legal profession celebrating here in San Diego each year Constitution Day. And of course, you know, what we're remembering is the signing of the Constitution back in 1787. And the day today recognizes the foundational principles of American democracy and encourages civic education and engagement. And speaking of which, I want to give a shout out to Judge Jerrilyn Malana, who is sitting in the back. Judge Malana is a member of the Power of Democracy. And for our legal community to know that the Power of Democracy is an initiative through our Chief Justice of California that focuses on civic education and outreach. And Judge Malana is a leader with the Power of Democracy. So welcome, Judge Malana. And also I'm also delighted to be here on behalf of California Lawyers Foundation, which is the charitable arm of the California Lawyers Association, and it's the largest voluntary bar in the state with over 50,000 members. As far as the foundation, we focus on a number of things, and that includes civic education and outreach. And so I'm delighted to be here to be part of the program with our top law professors on our program. So our discussion today will focus not only on the Constitution, but also on the importance of civility in discourse, but also in the practice of law. So today is an opportunity for us to not only reflect on the Constitution, but on civility and respect. So with that, I'd like to go ahead and introduce our top law professors, and I'm looking for our, yep, all right, here we go. Our first speaker is going to be Professor Semararo. Professor Semararo teaches at Thomas Jefferson School of Law, and he's been there over 26 years. He attended Stanford Law School, and then he clerked at the 10th Circuit Court of Appeals and practiced in Washington, D.C. at a private law firm. And then he joined the U.S. Department of Justice Antitrust Division, where he led the civil antitrust investigations of the optical disc and credit card industries. And then he served as, in 1996, he served as a special assistant U.S. attorney prosecuting criminal cases. And fast forward, Professor Semararo also authored the law professor's amicus brief in the U.S. Supreme Court on a seminal case called Verizon versus Trinco, which is a major U.S. Supreme Court case on antitrust law. And a couple of fun facts. One, first job out of law school, Tulsa, Oklahoma. But I think the coolest fun fact is that he plays in a band, a rock and roll band called Innocent Bystanders. Love that title. And you can hear his music on Spotify. So Professor Semararo will be our first speaker. And then I'd like to go ahead and introduce our second speaker. And that is Professor William Aceves from California Western School of Law. Professor Aceves teaches in civil procedure, constitutional law, critical race theory, human rights law, and he's also extensively written in these areas as well. Now, Professor Aceves has represented several organizations as amicus counsel in cases before the federal courts, including the United States Supreme Court. And he has appeared before the Inter-American Commission on Human Rights, the United Nations Special Rapporteur on Migrants, and the U.S. Commission on Civil Rights. He serves on the national boards of the American Civil Liberties Union, the Center for Justice and Accountability, and the American branch of the International Law Association. So fun fact for Professor Aceves, super fun. When he first got to San Diego, he tried to learn to surf, but then he got seasick, so he had to stop. So thanks for sharing that fun fact, Professor Aceves. So with that, I'm going to turn it over back to our first presenter, Professor Stephen Semararo.
Thank you. So this is a big thrill for me to be able to speak at this event, and especially because I see several of my students who are in the audience. I actually taught a class this morning at 10 o'clock, and a couple of them are here. But also there's a student from the very first class I taught, like forever ago. And so it's really a thrill for me to be able to speak in front of them as well as the rest of you. So I'm not sure what's going on right now because my PowerPoint was showing great, and now it's gone.
On Teams. We're adding it to Teams.
Okay.
My apologies.
So my talk is going to be about the structure of the Constitution, but I'm going to start out by addressing a little bit, before we talk about what the structure of the Constitution actually is, talk a little bit about why the Constitution looks the way that it does. Right? The founding fathers who put together the Constitution faced a number of challenges. Right? This was not an easy thing to do because there were a lot of concerns. Right? The original colonies were separate and independent sovereign entities. And they were nervous about the fact that now there was going to be this federal government that was going to be the supreme law of the land. And so they had to deal with these challenges. So there's probably a number of different challenges, and Professor Aceves is going to address some of the more specific ones, but I want to talk about three general ones. So first, the states feared that the federal government would override state sovereignty, that they would no longer be the final authority on things governing their states. Second, most Americans, many Americans, feared the notion that too much power would be placed in a single person. Having recently rejected the monarchy in England, they wanted a system that was different from that in some sense. And then, perhaps the most important, but also the most difficult to explain, is that the framers feared the formation of something that they called factions that would dominate the government at the expense of the common good. And it's important to focus on, what did they mean by this, right? And so a faction certainly could be a minority that somehow got itself into position where it controlled the government and could take advantage of that. But the framers were very clear in saying that when they spoke of the problem of faction, it was not simply that minorities could get control of aspects of the government, but that even a majority of the people could be a faction. And what distinguished faction from good government was the motivation behind it, right? Factions looked at aspects of their own self-interest that they wanted to advance without necessarily thinking about the common good. What the framers thought was essential was that the federal government be focused on the common good. And the way that we got there was through civility and cooperation and compromise. And so they strive to develop a federal government that would foster those things. So let's talk for a couple minutes about the ways that they tried to address the challenges that they faced before we get into the way that they actually structured the Constitution. So first, with respect to a federal government that would be able to sort of stomp on the states, they created in the Constitution a federal government of limited powers. The only thing that the federal government could do would be the things that the Constitution explicitly said that it could do. All other powers would remain with the states. Now, as most of you probably know, at least those who've studied the Constitution, that wasn't quite good enough. There was a lot of nervousness still. And so some explicit prohibitions on things the federal government could not do were also included. And we'll both talk about some of those as we go along. Second, with respect to the idea that a single person or small group would have too much power, the framers tried to build a system of checks and balances. Not just one check, but a system that would work together, right? So the only way for something to become a federal law would be for Congress to pass it. But Congress did not have the authority to do that by itself. The president has the power to veto laws passed by Congress. But Congress has the power to override vetoes if enough people in Congress agree that that's what should happen. Right? This is what our Constitution says. And I remember when I was a kid, these kinds of things happened all the time. They don't seem to happen anymore. I can't remember the last time I heard of a president actually vetoing a law, much less Congress overriding a veto. These things were built into our Constitution. Now, this could just be because it's working so well now that we don't need these checks, or maybe not. Let's think about that. But this is not the only checks and balances, right? The Constitution explicitly provides for the president to appoint leaders of the federal government, but for Congress to provide its advice and consent on those appointments. Now, we often hear now about the Senate approving presidential appointments. We don't hear a lot about the president looking to the Senate for advice on who should be appointed to top roles in the government. And this is something that has probably been going on for a long time now, where the framers thought it important that the Senate and the president work together, the Senate providing advice. And that's an important aspect of the original Constitution that is rarely seen now. And then finally, the Supreme Court was required by the Constitution to interpret federal law. So a law that was passed after it's been passed, and as we know from sort of everyday life, anytime you write something down, circumstances are going to arise that don't fit exactly, precisely into the words that were written down. So how are we going to apply those words to that situation? The way that the Constitution was set up is not just a decision for Congress who passed the law, not just a decision for the president who enforces the law, but the Supreme Court has the power to interpret that law and tell the other two branches what it is. Now, if that's a matter of statutory law, Congress can change it, and the president could veto those changes or sign them, but it's an extra level of check and balance that is part of the system that was built. Now, the hardest part, of course, of what the framers needed to do was how to deal with this problem of faction, where some group, whether a minority or a majority of the people, would take control of government and use it to serve interests that favored them without taking account of the common good. And so one of the principal ways that the framers sought to do this is something that we rarely think about anymore. And to the extent that we do think about it, we kind of think it's a bad thing. But I want to raise it as, maybe it is a bad thing, but it's something that we should think about. Why did the framers choose to do it this way? And what they did was they put into the Constitution 3 different ways of choosing the people who would lead the federal government. Members of the public would directly vote for the House of Representatives. Senators would be chosen by state legislatures. And then the president would be elected by a group of electors chosen in each state in a way that the state decided would be best for choosing those electors. Now, of course, we don't choose senators through state legislatures anymore. We have a public vote for them. And every state uses a public vote to choose electors to vote for the president. There are some differences. Many states, most states, have a winner-take-all system where whoever wins the popular vote in the state gets all the state's electors. But some states do divide it by district, where electors can be attached to a presidential candidate based on them winning that district. So this different ways of electing people was a critical factor in minimizing the risk that faction would dominate. Now, what was the reasoning behind this? So George Washington had a quote that I think is one of the best for understanding what happened. And he said, "The common and continual mischiefs of the spirit of party," and he was referring to the idea of political parties here, "are sufficient to make it the interest and duty of a wise people to discourage and restrain it." And so what I take that to mean is that the framers of the Constitution were trying to strike a balance, one in which there would be democratic participation of the people to ensure that the government was answerable to the people, right? There would be no king, no one who was above the people, no one who could not be removed from serving in the government. But the tendency of people to succumb to factious appeals required what Washington referred to as a wise people. The idea that, just because you can get one more vote than the other person doesn't mean that you should have the freedom to do whatever you want because you won the election, right? And this is the sense of, it's been sort of a common thing to say over the last few years that we don't live in a democracy, we live in a constitutional republic, right? But what that means is that there is a duty on the part of representatives to recognize that just because you win an election doesn't mean that you can advance factious interests. It means that you were the one who was chosen to try to serve the public interest, considering the interests of all the people, not just the ones that voted for you. Now, the framers tried to build this into the system by having different ways of choosing who those representatives would be. And we have gradually moved away from that towards a system that favors public voting. And that worked for many, many decades, I think, because people who were elected recognized the principle that just because you were elected in a democratic election didn't mean that you could ignore the interests of all members of the public. And that, I think, is our biggest challenge today. So with that introduction, let's go through the parts of the Constitution just to sort of get a basic understanding for how it's set out. Article 1 deals with Congress, and it specifically lays out a set of areas in which Congress can make laws. Any other area, Congress is not allowed to legislate. But as I said earlier, the idea of a limited government where the federal government would be limited to just what was actually in there was a pill that was too hard to swallow. And so there was demands that explicit prohibitions be included in the Constitution as well. And so a few of those in Article 1, and there are others, is the prohibition on bills of attainder, laws that would impose criminal liability on a particular person, the taxing of the transfer of goods between the states, and the idea of suspending habeas corpus, at least in peacetime, were things that Congress was explicitly forbidden to do. Section 2 sets out the presidency of the United States. And going back and reading Section 2 was really kind of an eye-opener because it's a remarkably short section of the Constitution, only 4 sections to it. And part of that addresses how the president is elected and how the president can be removed from office if there's unhappiness with the president. When we focus on what the actual powers of the president are, there are really only 4 things. They have the executive power to enforce the laws of the United States. They have the appointment power with the advice and consent of the Senate. They are commander-in-chief of the military, but of course only Congress has the power under the Constitution to declare law. And then the president has the power to pardon people for crimes. So many of these sections are extremely controversial today. And in particular, I just want to say a couple words about the executive power to enforce the laws. It's unclear exactly what the framers thought that meant. In the 20th century, there was a concern in Congress that the way that the federal government is administered shouldn't wildly swing from one set of policy priorities to another every time a new president was elected. And so an administrative system that was supposed to be independent of the president, not completely, but to a large extent, was set up. And these were laws that were passed by Congress, signed by the president, obviously. Now, there's a concern that does that system in which federal government regulatory power, whether it's the Federal Communications Commission, the Federal Trade Commission, or many others, whether that power actually violates the Constitution because it's someone other than the president who has the power to enforce the law. And that's a key question that is going to be resolved by the US Supreme Court in probably the near future. Article 3, of course, which is close to the heart of everyone who's in law school, is where it sets out the courts of the United States. The Constitution only creates a Supreme Court, but it empowers Congress to create inferior courts, which Congress did as one of the very first acts of the under the Constitution in 1791. These judges are empowered, as I said before, to interpret federal law, creating an additional check and balance on how the laws are interpreted, right? This was part of the original Constitution, that the Congress doesn't get to decide all by itself what the laws mean. The president doesn't get to decide. Administrative agencies don't get to decide. The courts ultimately get to decide what the laws mean. And the Constitution added one important specific that we should mention, recognizing that this might put judges in a difficult position sometimes. The Constitution required that they have lifetime appointments to protect their ability to interpret the law impartially. Article 4 of the Constitution sets out a system essentially defining a requirement that all of the states respect each other as equally sovereign entities. And critically, with respect to current events, it placed an obligation on the federal government to defend states against invasion from the outside, but also from domestic violence. With respect to domestic violence, though, as opposed to invasion from the outside, the Constitution explicitly said only upon application of the state legislature or of the executive, the governor of the state, when the state legislature could not be convened. It's amazing how, looking back at the Constitution, things were anticipated that still play out today in the kinds of issues that we're facing. Article 5, and this is where I will wrap up, it sets out a system for amending the Constitution. Professor Aceves is going to talk a lot more about this, so I'll only say a few things. One is that the amendment process was essential to the adoption of the Constitution because, despite the notion that it was a limited government, only able to do what was explicitly provided for, and even though there were some explicit prohibitions built in to Article 1, limiting what Congress could do, there was a sense that more protections were needed, particularly for individuals. Things like the ability to free speech, protection of personal privacy, the right to bear arms, protections against cruel and unusual punishment, excessive fines. And so these things were all added to the Constitution as specific prohibitions on the federal government through the first 10 amendments. In the Civil War, there were 3 critical amendments that guaranteed equality in how the government treated people in the United States. Other amendments did things like changing how we elected the senators, from being chosen by state legislatures to a popular vote structure, and requiring that women be permitted to vote in federal elections. Interestingly, the Constitution has not been amended in 22 years, but really it hasn't been amended in 50 years. The one that happened 22 years ago was actually proposed in 1798, but just never followed through on. And all that it said was that when Congress passes a pay raise for itself, it can't actually increase its own salary. That increase has to wait until another election happens. So that was the most recent amendment 22 years ago. Beyond that, there hasn't been anything in 50 years. And the one 50 years ago was reducing the voting age from 21 to 18. So that's the structure of our Constitution, along with some of the challenges that the framers of the Constitution believed that they were facing in drafting the Constitution this way. Thank you.
Thank you, Professor Semararo. That's fascinating, right? To have an opportunity to reflect on how our Constitution was formed, and just interesting on the prevention of factions, which thank you so much for highlighting that. For Professor Aceves, he is going to talk about amendments, but also some of the problems that currently remain in our Constitution that I don't think even we as legal professionals realize, but there are problems in the language of our current Constitution. So with that, I'll turn the floor over to Professor Aceves.
Hi, good afternoon, everyone. I have to say, this is a day of firsts for me. I've never had a shout out from a judge, which is a really cool thing. I wish my students had heard that. And I've never sat at defense counsel table. Hopefully that will be the end of the firsts. So Constitution Day is a day about celebration, to be sure, but I think it's also an opportunity for reflection, and perhaps even an opportunity for critical reflection. When we think about civility, civility includes the ability for us to have meaningful conversations on difficult subjects and to be able to address them and confront them head on. And so when I thought about what options there were to talk about the Constitution today, there are dozens, if not hundreds, of different opportunities. Equal Protection Clause, the Due Process Clause, the freedom of religion, the freedom of speech. But I wanted to focus on the acknowledgement of the Constitution that maybe there will be a time for a change. And I do think that the Constitution needs an update. And as we've heard, it has already been updated a few times, but I think more updates are necessary. So there, as Professor Semararo pointed out, there's an entire provision in the Constitution devoted to constitutional amendment. And I don't want you to spend any meaningful time looking at that, because I'm going to simplify it for you. That the Constitution, the fact that it acknowledged that amendments might be necessary is an incredibly important recognition. And there were two distinct methods recognized in terms of amending that document, but ultimately they require a significant majority of states to approve those amendments. In terms of the number of amendments that have occurred over the past 220 years, 27 amendments have been adopted to date. Obviously, we have the first 10 amendments, the Bill of Rights, but then we've had a number of other amendments, some perhaps more significant than others, and there have been hundreds of amendments that have been discussed over the years. As you can see here, we've had from granting the District of Columbia electors in the Electoral College, something I think is relevant today in terms of the impact that the federal government has on the District of Columbia. There are conversations today about the number of times a president can be elected president. That is being discussed now. And there have been various other amendments adopted over the past 220 years. Interestingly, one of the more significant amendments that was not adopted was the Equal Rights Amendment, and this came very close to being adopted. It was initially proposed in 1972, and it was designed to include gender equality in the constitutional text. While it was approved by Congress and a number of states did approve it, it did not reach the required threshold. And so it was not until 2020 when Virginia ratified the ERA, becoming the 38th state to do so, which would meet the requirement under the Constitution, but by then it was too late. There have been attempts to litigate whether or not the Equal Rights Amendment did in fact meet the ratification requirements, but no court has recognized that. So the ERA has not entered the constitutional text. I wanted to talk about two things that they didn't teach us, they didn't teach me in law school, that I thought were interesting to reflect upon with respect to the Constitution and amending the Constitution. One is the sequential model that we actually use. When we amend the Constitution today, we don't cut and paste, we don't find and remove, we simply add the amendment to the end of that document. So if you've got a hard copy of the Constitution, you would simply add another page to it as an appendix. That is the sequential or appendative model that we have used. But that's not the only way in which the Constitution could be amended. It could be amended through the integrative model. In that approach, you would literally go into the text of the Constitution and make revisions, cut and paste, remove offending language and add corrective language to that. There is no requirement for us to follow the sequential model, but through historical political compromise, that is essentially what was done. The second thing that I think is interesting to reflect upon is the lives of zombie laws. These are laws that have been held unconstitutional, for example, by a court or held inapplicable. What is interesting about a law that has been struck down by a court is that it does not remove that law from the text of whatever legislative code it appears in. That law simply becomes inapplicable because the court has deemed that it is not constitutional or it otherwise is invalid. But the law remains on the books. And I think it's interesting to reflect upon that as it relates to the constitutional text as well. Because we don't remove language in the constitutional text through amendments, there are provisions in our Constitution in 2025 that are outdated, archaic, and offensive, quite frankly. So again, if you were to look at the constitutional text, you wouldn't see any cut and paste, you wouldn't see double strike, you would simply see additional amendments attached at the end of the document. So what are the provisions that I'm referring to? Article 1, Section 2, the 3/5 clause that was adopted as a direct response to the fact that slavery was recognized, although never stated in the constitutional text. Article 1, Section 2 still exists in the document that we celebrate today. Article 1, Section 9, the importation clause. As you look at the language of Article 1, Section 9, you see that it talks about the migration and importation of persons. People migrate. Property is imported. Again, Article 1, Section 9 refers to enslaved people being treated as property. Article 4, Section 2, Clause 3, Fugitive Slave Clause, that empowered states to take back control of an enslaved person that had freed their territory. And then surprisingly enough, even the 13th Amendment, we celebrate the 13th Amendment as one of the core Reconstruction amendments. Note, it didn't outlaw slavery. Slavery and involuntary servitude continue to be recognized by our Constitution if it is the result of a conviction. So we certainly celebrate 13th Amendment, and rightly so, the 14th Amendment, the 15th Amendment, the Reconstruction Amendments, but recognize what it did and what it did not do. Because of the sequential model that we use, those provisions continue to remain in the constitutional text. And so the other things I wanted to suggest about what they did not teach us in law school is that those clauses remain. They have not been excised by any constitutional amendment. And so to the extent that we celebrate the Constitution today, we celebrate that document. To the extent that we convey and share this document with other countries around the world, we convey that document. And I think it's important for us to fully confront the beauty of that document, but also the flaws, the historical shortcomings of that document. And because those provisions continue to exist, they can be reinterpreted. They can be reanimated by those who choose to reanimate those provisions. When we want to, we can repeal a constitutional provision. The 18th Amendment, prohibition, didn't last very long, and it was repealed by the 21st Amendment. Note the language. The 18th article of amendment to the Constitution of the United States is hereby repealed. That isn't used in the 13th Amendment, 14th Amendment, 15th Amendment. And so what I'm suggesting is that it's time to modernize the Constitution. It is time to make that Constitution the truly great document that we think it is. We should remove the 3/5 clause, the fugitive slave clause, the importation clause, and the slavery clause from the Constitution. It would excise human bondage from that document that we celebrate. To be very clear, it would not remove that history. For those who fear that removing those words would somehow excise that history or allow us to turn our backs on that history, it doesn't do that. It can't do that. That history stays with us. It will always be with us. But by being able to remove that document, it can make this a document that we are truly proud of, that we can truly celebrate without equivocation. I'll comment, how would you amend the Constitution? Thank you.
Thank you, Professor Aceves. It really makes us stop and think, like, why have we not excised those provisions after decades and decades and decades? So you bring up a good point, and I think all of us have something to ponder. Now, I'm going to take a look at, let me just do this. Going to now take a look at some of the questions that you have. So here we go. The first one I wanted to touch on is civility. Why is civility important in a constitutional democracy? And I just open up to the two of you to answer. Again, we want to focus on civility.
Would say that we live in a deliberative democracy, and that deliberative democracy requires communication, requires conversations. In the absence of that deliberation, this system of government breaks down. And so to be able to have meaningful conversations about difficult subjects, you have to be able to have those types of open, that type of open discourse. So I think initially I would say, yes, we are a constitutional democracy, but more importantly, we're a deliberative democracy where dialogue and communication is essential.
Thank you. And Professor Semararo.
Yeah, I agree. And that's in my talk, I talked about how the founding fathers sort of assumed that it was essential to have compromise, deliberation, and a willingness to work together to pursue, some sort of a public good. And I think it's important, though, to think about what we mean by civility in government. It certainly was the case in the time of the adopting of the Constitution that there was vigorous debate, and it was heated. And even if you look at things like the presidential election and advertisements and posters, there was all kinds of things that we would think is very offensive today. But what was meant by civility was not so much the way that you present yourself, but what your goals ultimately should be, right? And the idea of civility in the Constitution, I think, is that we should all be pursuing what is best for the entire country, the general good, and we should recognize that we have to compromise to get there. And so we can have very vigorous debate, but we have to be focused on that effort to bring things together rather than to just sort of defeat the other side.
Thank you. All right, I need my glasses for this one. With this current state of affairs, do you have any concerns with the viability of our democracy continuing on another 200 years? What concerns do you see with what seems to be an erosion of respect for the judicial branch, and how can this be rebuilt? Excellent question.
Those are two different.
Okay, we'll start with the first one. With this current state of affairs, do you have any concerns with the viability of our democracy continuing on another 200 years?
Yes, because I think that we've lost the understanding that democracy is part of a process that prevents the government from being dominated by, the sort of idea in traditional classic monarchies. It's not a system for saying the government should only serve the people who voted for those people and not others. And it seems like we've lost that, and not just in recent years. I mean, I feel like for at least the last quarter century, we have sort of lost that sense that democracy is a way of ensuring that the government serves everybody's views, not a way of picking the particular views that the government's going to serve.
Thank you. Professor Aceves.
I would agree. When I teach my classes in constitutional law, I try to be an optimist by nature, but I have to be very candid with this next generation of students that what they will be confronting is very different than when I confronted in law school and thereafter. And so what are the solutions? Well, I've talked about the amendment process, but note the amendment process requires 3/4 of the states to agree. And the way in which the current system has been structured, it's very difficult to see that actually happening, certainly with any significant structural changes. And so that's actually one of the reasons why I like the idea of amending those provisions of the Constitution, because it really doesn't appear to be a partisan dynamic at work there. It doesn't benefit one side more than the other. It is a set of amendments that could generate consensus and open the door for conversations about other more provocative amendments. And that, I think, is also a key aspect of civility. We're not going to agree on everything. So let's find what we can agree on and use that as an opportunity to then open the door for conversations about other difficult questions, life tenure for Supreme Court justices, the structure of the Senate, what is going to be the 51st or 52nd states. Those are difficult, very partisan-based questions, but they need to be confronted. And right now, it does not appear that there's a way to do that. So what is an opportunity for us to bring people together and at least come to agreement on certain points? And again, for whatever it's worth, I think that addressing those vestiges of slavery in the constitutional text is a nonpartisan issue.
Thank you. You know, I do want to get to this point here on the independence of the judiciary, you know, the third branch, co-equal branch of the government. So the question, again, I'll ask, what concerns do you see with what seems to be an erosion of respect for the judicial branch, and how can this be rebuilt?
So I'm going to focus on a very specific aspect of respect. I'm going to talk about vertical respect within the court structure. My concern is that the Supreme Court, the U.S. Supreme Court, is disrespecting a lot of lower court judges in a myriad of ways. For example, as many of you know, there's the emergency docket, also known as the shadow docket, where the court is issuing these abbreviated opinions that may be one paragraph long that they expect the lower court judges to then execute. But there's no meaningful analysis. There's no meaningful foundation for what is the basis, what is the precedent that you're relying upon. And so lower court judges are being asked to interpret opinions that have almost no substance to them. And then the court is criticizing those lower court judges for doing that. I think that the notion of respect has to start at the top, and that's with our current Supreme Court. And so I hope the justices recognize that what they say about lower court judges matters. And so I appreciate there's a lot of concern about horizontal respect, but I'm also very sensitive to that vertical respect that needs to also exist.
I agree with that. I would say that with respect to what was probably motivating the question, the idea of horizontal respect between other branches and the court, that sort of criticism, I think, that concern is a lot less troubling because that's nothing new. It dates back to the early 1800s of presidents and Congress criticizing the court harshly for decisions that it made because they disagreed with them. And there's nothing necessarily wrong with that as long as the decisions of the court are ultimately respected and upheld and changed through proper means, whether it's Congress enacting new laws or amending the Constitution.
Thank you. This is sort of a follow-on. Can we continue to hope the Supreme Court will abide by the Constitution and legal precedent?
Oh, that's what they're going to do. We might disagree with their interpretation, but it's their job.
I would agree. I have no doubt that the members of the court sincerely believe that they are implementing the constitutional text as they interpret it, which of course is the challenge of any system that accords such significance to the judiciary.
I will say add one thing to that.
Yeah.
One of the sort of interesting animating principles of the current court is, especially in dealing with law that takes into account race, what is this notion that we held that it was constitutional to take race into account in different areas, but voting, education, things like that. But at some point, the system of equality needs to prevail, and we need to end those provisions that were maybe necessary for a time to sort of restore equity. And so to some extent, the court has done that. But unfortunately, their sort of apparent view that these things were no longer needed because so much time has gone by, just the opposite has been true. The second those prohibitions were gone, the same concerns that led to them in the first place have been readopted. So the court may have been acting in good faith. I think an important question is, will they recognize when they've been wrong?
Good point. Good point. All right. This is a question for you, Professor Aceves. Given recent efforts to erase other parts of history, including slavery, is there a benefit in required readers of she's gonna
So with respect to laws that have been found unconstitutional or otherwise inapplicable by state or federal courts, as I mentioned, they still remain in the code. They still remain in the Constitution. And so the question then becomes, what do we do with that? I don't have the concern that directly confronting those types of laws and removing them would erase that history. Because the concern I have is that those laws that have been held in abeyance because of a legal decision could immediately be reinstituted. And we saw that after Dobbs. There were countless trigger laws in many jurisdictions, many states around the country, that as soon as Dobbs was issued by the Supreme Court, it immediately reinstituted those laws. And so I do think it's important to confront that. And there are any number of ways. With respect to the constitutional text, I do believe an amendment is necessary to remove that language that one is concerned with. I think if it's a state law or a federal law that Congress has adopted, I almost think that once a year, every few years, every legislature should review the laws that are on the books and excise those that are no longer applicable. Why? Because the following year, a court might reinterpret that law and reinstitute it, or it might interpret another law that has an impact on that law that you fear about. So I think that idea of periodically reviewing the laws that are out there and excising those that are no longer relevant is important, because otherwise they stay there. And that's why they're called zombie laws. Zombies remain there. They're hiding, they're waiting for you. And then they jump out at you at the last minute that you expect, and they wreak horrible havoc. And there's so many different TV shows that show that. So that's my fear with those laws. And I think it's much better to confront them head on, because that will not in any way end the history that underlies those laws.
Thank you, Professor Aceves, and thank you for clarifying your question. We're at time, and I wanted to give our distinguished professors, a minute each to maybe give, your parting thoughts to our audience on the importance of Constitution Day and civility. So with that, how about Professor Semararo? 1 minute. There you go. Lightning round.
Okay. Well, we often hear the phrase that there's a price for peace. That when there's conflict, you cannot reach peace without both sides paying a price. And I think that it's important to look at democracy the same way, right? Probably all familiar with Winston Churchill, I think it was, who said that democracy is the worst form of government except for all of the others. And what I think that conveys is the idea that there's a price for democracy, that you can't simply say we're going to hold an election and whoever gets the most votes can do whatever they want. We have to recognize that as an elected official, you have to understand that there are things that you need to do that are not going to please the people who elected you. And what Professor Aceves was just saying, every year or every few years, legislatures should go and excise the laws that have been held unconstitutional. To the extent that a lot of people disagree with that court holding that those things are unconstitutional, they're going to be mad if the legislature does that. But the legislature should do that because that's the price of living in a constitutional democracy. And that price has to be paid. And the thing that scares me the most is that it feels like we have forgotten that price has to be paid.
Thank you. Professor Aceves, 1 minute lightning round.
We've been talking about the importance of civility and engagement. And I have to say, it is so cool to be a law professor in a courtroom talking about these issues. I hope that judges would encourage law school students to come here more often and do this. I would hope that judges might invite legislators to come to the court. And maybe legislators would invite judges to the court on a regular basis. That's what engagement is. That's how you promote civility. There was a book written a number of years ago called Bowling Alone about how Americans are more and more isolated and separated from their colleagues, their families, their neighbors, and that what once used to happen all the time, bowling leagues, had disappeared. And so I think it's important for us to find ways to re-engage. Civility is about engagement and community. And the more we can do that and bring people and cross-pollinate experiences and lives and livelihoods, I think the better off we will all be. So I hope this isn't the last time I'm here. But again, I don't want to be on the defense side.
Thank you so much, Professor Aceves. Please join me in congratulating both Professor Aceves and Professor Semararo on a very, very thoughtful program, for all of us to take away. And with that, I wanted to put out a challenge to especially our lawyers, also our judges, to get involved, in civics and civic engagement. For our judicial officers, I encourage you to connect with Judge Jerrilyn Malana in the back. There are programs, Judges in the Classroom, and other outreach programs that our judicial officers can get involved with. For the lawyers, connect with the San Diego County Bar on their programs. Also, I'm happy to chat with you as well. There's a local civic learning partnership who can certainly use lawyers to go out and engage with students at all levels. So there's a way for you to get involved, and also a special announcement. I promised to make mention, there's something special for the lawyers that's new. We encourage you to get involved in the mock trial program. And they are looking for coaches. And yes, we know that's a big time commitment where you're a coach to high school students for mock trial, but we need more coaches and we need more scores. But guess what, lawyers? You can now get CLE credit. 2 hours, right, Scott? 2 hours of CLE credit. And I think that is wonderful and a change. And if you can help us spread the word. So those are ways that you can get involved. But with that, thank you so much for attending our first inaugural Constitution Day with the San Diego County Bar Association. Thank you.